If you've been injured in an accident and you're wondering why your attorney hasn't sent a settlement demand yet, you're not alone. It's one of the most common questions we hear. The answer almost always comes down to three letters: MMI, also known as maximum medical improvement. Most injured Virginians have never heard this term before their accident, but from the moment your case begins, it controls everything. It controls when your attorney can properly value your claim. It controls what your settlement is actually worth. If you don't understand it, the insurance company is counting on that. Because here's the thing, the insurance company understands MMI perfectly, and they use that knowledge against you every single time. In this video, we're going to break down exactly what maximum medical improvement is, how your doctor determines it, what happens to your case once you reach it, and why settling before that milestone could cost you everything you're owed. My name is Gray Broughton. I'm a Virginia personal injury attorney and a veteran. At Gray Broughton Injury Law, we represent people across Virginia who've been seriously hurt through no fault of their own. We prepare every single case as if it's going to trial. And one of the most important things we do for every client is make sure they don't settle their case before they understand what it's actually worth. That's what this video is about. By the time you're done watching, you're going to understand MMI better than most people who've been through the entire claims process. You'll know what it is, how it works, what it means for your settlement, and exactly what the insurance company is hoping you don't know about it. Let's get into it. Part 1, what maximum medical improvement actually is. The American Medical Association defines maximum medical improvement as the point at which a condition has stabilized and is unlikely to change, improve, or worsen substantially in the next year, with or without treatment. In plain English, MMI is the moment your doctor determines that your body has recovered as much as it's going to recover. Now here's the critical piece that trips people up. Reaching MMI does not mean you're fully healed. It doesn't mean your pain is gone, and it doesn't mean you're back to normal. It simply means your condition has plateaued and isn't expected to improve further in any meaningful way. Think about what that actually means for some common injuries. Let's say you suffered a spinal injury in a Virginia car accident. You went through injections, physical therapy, and even surgery. You still have nerve pain and reduced strength on one side. You're probably not going to get better than that since that's what your doctor says. That's MMI. You're not healed, but you've reached the maximum benefit medicine can offer you. Or let's say you had a serious fracture. The bone healed and you finished physical therapy, but you still feel stiffness going upstairs and soreness after long walks. Your doctor says that's your new baseline. That's MMI. MMI gives your case the clarity it needs to move forward. Before MMI, no one can say with confidence which your injuries are going to cost you for the rest of your life. After MMI, that picture becomes clear. And that picture is what your settlement needs to be built on. Part 2, how your doctor determines MMI. MMI isn't a legal determination, it's a medical one. Your treating physician makes this call based on physical evaluation, a review of your medical records, your diagnostic imaging, and your clinical findings over time. What they're looking for is stabilization. When your progress stops, when treatment responses flatten out, when further care isn't producing meaningful improvement, that's when a physician will document that you've reached maximum medical improvement. Now, there's an important nuance here that most people don't know about. MMI isn't always a single moment. It can happen in stages. A client might reach MMI after conservative treatment, like physical therapy, but still need surgery for a different aspect of the same injury. That means their case isn't fully ready to be valued yet, even if the physical therapy portion has plateaued. This is exactly why experienced Virginia personal injury attorneys don't rush to send a demand package the moment a client feels somewhat better. We're making sure we're capturing the full picture of what your recovery actually looks like, including all the stages, before we put a number on what you're owed. There's also something else you need to know. Insurance companies sometimes request what they call an independent medical examination, or an IME, conducted by a doctor of their choosing. They use these exams to argue that you've reached MMI sooner than your own physician believes. We've talked about this in a previous video on this channel, but it bears repeating here. There is nothing independent about an IME. The doctor performing that exam has a financial relationship with the insurance company, and their reports almost always minimize your injuries or claim you've recovered faster than you actually have. An MMI determination from an IME doctor can be challenged, and when we see it being used against our clients unfairly, we do challenge it. Part 3, what happens to your case at MMI? Once you reach maximum medical improvement, your attorney can finally build a complete picture of your damages. Here's what that actually includes. First, past medical expenses. Every dollar you spent on treatment from the date of the crash to the date of MMI. Emergency room visits, surgeries, physical therapy, medications, specialist appointments, all of it. Second, future medical expenses. Once MMI is reached and your doctor can say what ongoing care you'll need, those costs become part of your damages too. That might mean future injections on a scheduled basis, pain management appointments, durable medical equipment, or additional surgeries that are still anticipated. Third, lost wages. Both what you've already lost and, if your injuries are permanent, what you'll continue to lose going forward because your ability to work has been permanently affected. Fourth, pain and suffering. This is where MMI really changes things. In Virginia, there's no cap on pain and suffering damages in most personal injury cases, but you can only accurately calculate those damages once you know whether your pain and limitations are temporary or permanent. If your injury is permanent, that permanency is documented after MMI is reached, and permanent injuries are worth significantly more than temporary ones. Not because of some legal formula, but because permanent pain, permanent limitations, and a permanently changed life deserve full compensation. The MMI report prepared by your physician is one of the most important documents in your entire case. It should clearly state that you've reached maximum medical improvement, identify your permanent impairment rating if one applies, list your permanent physical restrictions and limitations, and outline the future medical treatment you'll need to manage your condition. A vague or incomplete MMI report is something the insurance company will exploit. A thorough one is something we build your entire demand around. Part 4. Why the insurance company wants you to settle before MMI. Here's what the insurance company is doing from the moment your crash happens. They're watching, calculating, and moving as fast as they can to get your signature on a settlement release before you understand the full extent of what you're dealing with. In the days and weeks right after a serious accident, you don't know if you'll need surgery yet. You don't know if your back pain will become permanent. And you don't know if your headaches are going to resolve or turn into something that affects your life for years. The insurance company is making an educated guess that you're worse off than you think, and they're offering you a fast check because they know that once you sign that release, the case is closed permanently. It doesn't matter if you need surgery 6 months later, and it doesn't matter if a specialist tells you your injury is permanent. You can't reopen it or ask for more. The door is closed forever. Settlement offers made before MMI are almost always far below what the case is actually worth. That's not an accident, it's a strategy. Let me give you a real example of why this matters. We've seen cases in Virginia where a client's immediate medical bills after a crash were under $25,000, relatively modest, and the insurance company made a quick offer that seemed to cover those bills, plus a little extra. But once that client reached MMI, their treating physicians documented permanent nerve damage that would require ongoing injections, pain management appointments, and restrictions on their ability to do physical work. Their future medical costs alone exceeded what the insurance company had already offered as a full and final settlement, and if they'd signed that release, they would have been on their own for every dollar of that future care. That's the real cost of settling before MMI. Part 5. What about the financial pressure while you wait? We hear this all the time. Great, I understand why I shouldn't settle early. I've got medical bills piling up right now. I've got a family to take care of. I can't just wait. We hear you, and we want you to know that waiting for MMI doesn't mean waiting without any financial support. There are options available to injured Virginians while their case is being built. Your own health insurance can be used to pay your medical bills while the case is pending. We can then pursue reimbursement of those costs as part of your settlement. We can also negotiate lien agreements with medical providers, meaning your care continues, but the providers agree to wait for payment until your case resolves. If you have MedPay coverage on your own auto insurance policy, that's another source of immediate funds for your medical expenses that exists separate from your personal injury claim. And if you have uninsured or underinsured motorist coverage, that coverage can become an important part of your recovery as well. The point is this: financial pressure is real. We understand that. But signing a settlement release before MMI to relieve short-term pressure almost always creates far greater financial harm in the long run. Our job is to help you navigate the pressure while protecting the full value of your case. Part 6. The IME tactic and how we fight it. Let's come back to the independent medical examination for a moment because it directly connects to MMI in a way that matters for your case. Insurance companies have a strong financial incentive to argue that you've reached MMI as early as possible. The sooner they can say you've plateaued, the sooner they can cap what they owe you. And an IME doctor is one of their primary tools for making that argument. Here's what typically happens. You're still receiving treatment. Your own physician believes you still have room to improve. The insurance company schedules you for an IME with a doctor who's done hundreds of these exams for insurance companies and knows what conclusions those companies need. That doctor spends 15 to 20 minutes with you, reviews some records, and sends a report back saying you've already reached MMI and don't need further treatment. Then the insurer uses that report to cut off your treatment coverage or to make a lowball settlement demand based on an artificially shortened recovery timeline. We fight this by building your case around your treating physician's determinations. They know your injuries. They've been with you through every stage of treatment, and they have far more clinical context than any hired examiner ever will. So, when an IME report contradicts your treating doctor, we challenge it with evidence, with expert testimony, and when necessary, in front of a Virginia jury. If you or someone you love has been injured in a Virginia accident, don't sign anything before you've spoken with us. At Gray Broad Injury Law, we represent injured Virginians across the entire state. We're a veteran-led, trial-ready firm that prepares every case as if it's going to court. Because when the insurance company knows we're serious, they negotiate differently. The consultation is free, there's no fee unless we win, and one conversation could mean the difference between a settlement that covers your bills and a settlement that covers your life. Call us today at 804-669-9899 or visit us at graybroughton.com. We're ready to fight for you. If you want to learn more about cases in Virginia, make sure to check out our next video where I talk about why your chiropractor visits matter far more than you think in a Virginia injury case.